All right. So today we're going to present to you. I'm going to present to you the department process for subpoena request. Subpoena request, and again, my name is Mr. Henry Apia. You can add that, and I'm the director for the Health Information Management Department here at Montgomery City Hospital. So what we do when we first receive subpoena from the court to turn in certain patient records, when we first receive that, what we do is we have to validate the subpoena, making sure it's coming from the court or the attorney. So we look at the court order, whether it's official or not, looking at the stamps and everything. Then we make sure the subpoena bears the court name and issuing presiding attorney, not the judge, but attorney. And also make sure the court seal is the date and time that the subpoena was submitted, and whether it's a subpoena ad testificandum or subpoena ducis tecum, okay, whether to testify or send a medical document. And we also look at the authorization of subpoena, where we have patient authorize and say, yeah, they give the go ahead for their records to be released, but this is always subjected to the state and federal laws. And some subpoenas, state and federal law can waive that authorization and go ahead without a patient authorizing it. Okay, and this can be found under the federal government authorizations, the Department of for Health and Human Services, and also is some thing that is stated under the HIPAA and the False Claim Act. Okay, we have to identify where we're going to get the information from, the sources of the information. We'll look at the scope of the information. We're going to look how much information is needed and how deep the information that the subpoena needs, So in identify, we're going to look at the electronic records, paper-based documents, lab documents, phone conversations, emails that we've had with patients, and what were the transcripts of such communication or interaction with patients that has been recorded. We have to look at all that and send it over. So once we identify the information that we want and where they are, we look at the preservation of the information, the security and avoidance of any corrections or markings, erasures, alterations, making sure we protect the information from being altered. Then we bring our teams together, different teams looking at different areas of the information. If it's phone conversation, emails and other, they have a team working on that. We have a team working on the electronic records, paper-based document, labs, and also things like diagnostic information. So teams will work in all these different areas, making sure information is accurate, up to date, no errors or any alteration. They are consistent with what we know patient was recorded on the patient. So all these audits, all this has to go through the audit, with the help of the team and certified. Then after that, we migrate. We bring all the information that we've collated from all these places, the hard copies from paper-based documents and all that, and put them into one data saved on a computer to be ready to be taken to the courts. And when we compile the information, we put together everything, summarize them, review, do review and summaries of the information, also analyze them well, making sure again they are accurate and everything that is needed is in there. Then we do the authentication for the legal process. That is the information that we've gathered. We make sure it's supported, whether it's copies that is sent out. We have original copies that support information on or are supported, or the information on the original and the copied ones are the same. No? And then we're making sure there's no differences, okay, that of what we send out and what we originally have. Okay, so we also sign off. We have electronic signature that should confirm the verification of the identity of the author of the information or the records. So this is put into a workflow. First of all, we do the validation of the subpoena, make sure it's a legal thing, it's genuine. Then we do authorization, where we look at patient consent and applicable laws, state and federal laws, because some of these state and federal laws can waive a patient's right to waive whether information to be waive whether information or her records impinge on his or her privacy or confidentiality. Then we do the identification, locating all these records, going into phone records and all that, and then conversation transcripts, paper-based records, and the preservation of the records, which basically we're protecting the original, authentic records or information. And we have assembled auditing team that work in different areas of the records. And after we put everything together, we make sure it's the right thing going into the courts. Everything matches well with patient record as it was recorded at the time patient comes in and all that. And this is the flow chart put into this diagram here, showing the validation, authorization, identification, preservation of records, the auditing teams, and the final compilations. And some states have different states have different regulations. The state of Georgia, it permits the use of subpoenas as a tool to do research or investigation of cases, medical cases. And again, patients have a right to privacy, and they can say that I don't want this infringes on my privacy or confidentiality. But these laws are not absolute, because the states or certain states and federal laws can actually move against patients' rights, in this regards, and can waive those rights with a court document or legal document. So in Georgia, the laws on medical records yes, spells out patient privacy and confidentiality, and with patient's consent before those medical records can be released. But this is not absolute, like I said. It does not apply in cases of subpoenas. In subpoenas, this can be waived. And these are the references. Okay, we'll come back here and talk some more going forward on this subject. Thank you very much.